Back in March, the Supreme Court argued the case Catholic Charities Bureau, Inc. versus Wisconsin Labor and Industry Review Commission. Now, I reviewed those arguments in my article, Are You Religious Enough? Now, in June, the court released its decision, and thankfully, the court came to what I believe is the correct decision, though that's not to say they came to the conclusion for the right reasons. So let's look at this decision next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your rising generation to be free. I'm glad you could join me today. Again, this is the opinion for a set of oral arguments I've already covered, so I'm not going to get into the details about those arguments. I want to focus on the conclusions and how the court came to those conclusions. That's our goal for today. Now, if you want to see all my resources and links, well, just go to constitutionstudy.com, find this article, and you'll find all of my quotes have links to where I get my sources, so you can double check my work. I'll talk more about the website and other ways you can actually support the work that we're doing here at the end of the episode. But for now, let's take a look at this Wisconsin religious liberty case. This case revolves around what at first seems to be a simple question. Does Catholic Charities operate for primarily religious purposes? The Wisconsin Labor and Industry Review Commission said no, and the Wisconsin Supreme Court agreed. Wisconsin law exempts certain religious organizations from paying unemployment compensation taxes. The relevant statute exempts nonprofit organizations operated primarily for religious purposes and operated, supervised, controlled, or principally supported by a church or convention or association of churches. Petitioners, Catholic Charities Bureau, and 4 of its sub-entities sought this exemption as organizations controlled by the Roman Catholic Diocese of Superior, Wisconsin. The Wisconsin Supreme Court denied the exemption, holding that the petitioners were not operated primarily for religious purposes because they neither engaged in proselytization nor limited their charitable services to Catholics. However, the Supreme Court of the United States found otherwise. Justice Sotomayor wrote the opinion, held the Wisconsin Supreme Court's application of Section 108.02, 15H2 to petitioners violates the First Amendment. I believe the court is correct that the state of Wisconsin violated the Constitution, but are they right about the reason why? Did the way the Wisconsin Labor and Industry Review Commission and the decision of the Wisconsin Supreme Court violate the First Amendment? Reading from the opinion, the First Amendment mandates government neutrality between religions and subject any state-sponsored denominational preferences to strict scrutiny. Actually, that's not what the First Amendment says. It reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So the First Amendment does not mandate general government neutrality, but that Congress not get involved in religion. Congress cannot establish a religion nor regulate religious practices. But the First Amendment specifically states this limitation is on Congress. Now, that's not to say that Wisconsin's actions do not violate the Constitution, both of the United States and the state of Wisconsin. Let's start with the Constitution of the United States. Under the 14th Amendment, we read, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor deny to any person within its jurisdiction the equal protection of the laws. The decision of both the Labor Board and the Wisconsin Supreme Court violated the Equal Protection Clause of the 14th Amendment. Reading from the opinion, the Wisconsin Supreme Court's interpretation of 108.02 15H2 imposes a denominational preference by differentiating between religions based on theological lines. Petitioners' eligibility for the exemption ultimately turns on inherently religious choices, namely, whether to proselytize or serve only co-religionists in the course of charitable work, not secular criteria that happen to have a disparate impact upon different religious organizations. Because that regime specifically differentiates between religions based on theological practices, strict scrutiny applies. So Wisconsin protects some religious organizations, but not others. That's the definition of denying the equal protection of the law. Now, if that's the United States Constitution's view, what about Wisconsin's? If it prohibits giving preference to religious establishments or modes of worship, Isn't that exactly what both the Labor Industry Review Commission and the Supreme Court of Wisconsin did? Next, Justice Sotomayor gets into the arguments of the state of Wisconsin. The state argues that when it comes to religious accommodations afforded by the government, courts should ask whether the accommodation's eligibility criteria are the product of invidious discrimination to determine if strict scrutiny applies. In support of that rule, the state draws on Gillette versus United States. Gillette, however, is an opposite. Wisconsin argued that when government makes an accommodation, the court should look at to see if the discrimination is invidious or obnoxious. In support of this argument, Wisconsin points to the case Gillette versus United States. Justice Sotomayor says this argument is inopposite or not pertinent. Unlike the conscientious objector in Gillette, which was equally available to members of all religions, the Wisconsin Supreme Court's interpretation of 108.02-15H2 facially differentiates among religions based on inherently theological choices. See, the remedies available to Gillette were available to members of all religions. But since that is the exact opposite of what the Wisconsin Supreme Court decided, they basically said that these entities of Catholic Charities were not religious enough. The state next disputes the premise that petitioners were denied coverage because they do not proselytize or serve only Catholics in the course of performing charitable work. The state instead claims that petitioners were excluded because they engaged in no distinctively religious activity, meaning activities that express and inculcate religious doctrine. So the state claims that Catholic Charities doesn't engage in distinctively religious activity. I guess all those verses about feeding the poor and helping the needy aren't religious enough for the Wisconsin Supreme Court. Justice Sotomayor agreed. That understanding of the Wisconsin Supreme Court's ruling, even if assumed correct, cannot save the statute from strict scrutiny because decisions about whether to express or inculcate religious doctrine while performing charitable works are fundamentally theological choices driven by religious doctrine. Notice Justice Sotomayor's analysis. Even if the state's argument was correct, it would still be wrong, not because it was unconstitutional, but because it would trigger strict scrutiny. That is the court-created rule about how hard a government entity has to work to infringe on your rights. Section 108.02-15H2, as applied, cannot survive strict scrutiny because the state has not met its burden to show that the law's application is narrowly tailored to further a compelling government interest. So the court claims that the application of the law does not survive strict scrutiny because it is not narrowly tailored enough. All the justices agree, but two justices wrote concurring opinions. Let's start with Justice Thomas's concurrence. A nonprofit organization is entitled to an exemption from Wisconsin's unemployment insurance tax on employers if it is controlled by a church and operated primarily for religious purposes. The Wisconsin Supreme Court concluded that Catholic Charities Bureau and its entities are not such organizations, reasoning in two steps. This is Justice Thomas's style. Break the argument down, then investigate them one by one. First, the court held that the relevant organization is Catholic Charities and each of its sub-entities, not the broader Catholic Diocese of Superior, of which it is a part. What's in a name? Is a Catholic charity, even one directed by the Catholic Diocese, still controlled by the Catholic Church and thereby religious? Second, it held that the purposes of Catholic Charities and its sub-entities are primarily secular, not religious. Since when is Christ's command to feed the hungry, care for the poor, and take care of the least of these a secular endeavor? The court concludes that the latter holding of the Wisconsin Supreme Court unconstitutionally discriminates against Catholic Charities and its sub-entities. I agree and join with the court's opinion in full. I write separately because, in my view, the Wisconsin Supreme Court's first holding was also wrong. So although Justice Thomas agrees with the court, he wants to argue that Wisconsin's first argument, that Catholic Charities is not part of a Catholic diocese, is wrong. The Wisconsin Supreme Court disregarded this structure of Catholic Charities and its sub-entities in adjudicating the case below. The court acknowledged Catholic Charities' status as an arm of the Diocese of Superior, subject to the bishop's control. It nonetheless viewed Catholic Charities and its sub-entities as distinct, non-religious organizations merely because they are separately incorporated. Justice Thomas points out that even though the court acknowledged that Catholic Charities was an arm of the diocese, they claimed it was a distinct entity. Now, it went further, claiming that this arm of the church, overseen by a bishop of the church, was a non-religious organization. By failing to defer to the Bishop of Superior's religious view that Catholic Charities and its sub-entities are an arm of the diocese, the Wisconsin Supreme Court violated the church autonomy doctrine. Notice that Justice Thomas doesn't claim that the Wisconsin Supreme Court violated the law, but the court's doctrine. This leads to the conclusion Justice Thomas came to. The court correctly holds that Catholic Charities and its sub-entities have suffered unconstitutional religious discrimination, even on the assumption that those entities should be considered in isolation. I would reverse for an additional reason. The Wisconsin Supreme Court violated the church autonomy doctrine. However incorporated, Catholic Charities and its sub-entities are, from a religious perspective, a mere arm of the Diocese of Superior. The Wisconsin Supreme Court should have deferred to that understanding, and its failure to do so amounted to an unlawful attempt by the state to redefine the diocese's internal governance. So Justice Thomas thinks the violation of a court doctrine, not a law or even a court order, is an additional reason why the Wisconsin Supreme Court violated the rights of Catholic Charities. Now, when it comes to the Supreme Court, Justice Thomas and Justice Jackson would seem to be an odd couple. However, in this case, they both wrote concurrences adding to the opinion of the court. I write separately because, in my view, FUTA's religious purposes exemption does not distinguish between charitable organizations based on their engagement in proselytization or their service to religious adherents. Nor does that exemption differentiate based on religious motivation, as the government, as amicus, insists. Rather, both the text and the legislative history of FUTA's religious purpose exemption confirm that Congress used this phrase, operated primarily for religious purposes, to refer to the organization's function, not its inspiration. Put differently, Section 3309B1B turns on what an entity does, not on how or why it does it. Justice Jackson is referring to the Federal Unemployment Tax Act and its religious purposes exemption. Specifically, she is referring to the language, an organization which is operated primarily for religious purposes and which is operated, supervised, controlled, or principally supported by a church or convention of association of churches. As she describes Congress's intent, here Congress sought to extend to most nonprofit workers the stability that unemployment insurance offers, while exempting a narrow category of church-affiliated entities most likely to cause significant entanglement problems for the unemployment system, precisely because their work involves preparing individuals for religious life. It is perfectly consistent with the opinion the court hands down today for states to align their 3309B1B-based religious purpose exemptions with Congress's true focus. Except the language she quotes says nothing about preparing individuals for religious life, only that it have a religious purpose. As I've already pointed out, there are numerous verses in the Bible that tell adherents they are to take care of the poor and needy, which is what Catholic Charities in general does. Now, as is so often the case, I believe the court once again came to the correct conclusion, but not entirely for the right reasons. As I've pointed out too many times to count, the First Amendment states Congress shall make no law. Congress did not make this law, and the state of Wisconsin could not violate the First Amendment. And no, the 14th Amendment didn't rewrite the First, as the court generally claims. This is a violation of the 14th Amendment's Equal Protection Clause, since the state of Wisconsin treats different organizations operated for religious purposes differently based on how their churches work. Justice Thomas also found that the state of Wisconsin violated Catholic Charities' rights, not by violating a law or the Constitution, but court precedent, which is neither law nor legally binding. Add to that Justice Jackson's rewriting the law passed by Congress to meet her own agenda, and I think I've exposed the erroneous logic of the court. I guess even a blind squirrel can find a nut every so often. I guess we can take the win, but personally, I want more. I want a court, a judiciary, an entire legal system that follows the law and doesn't make it up for themselves as they see fit. That's why I cannot be satisfied with this court's decision. When I was in high school, there were certain questions, either in tests or homework, where I was required to show my work. I had to show how I came to the answer, because how I came to the answer was just as important as the answer itself. That's kind of how I feel here. The court got the right answer, but their method of getting there is fundamentally flawed. That's important because without the foundation of the method was to keep them from coming to a different decision. Was to keep the court from saying, yeah, this one's okay. We don't need strict scrutiny here. I've got no basis for it because they're basing things not on law, but on their own opinions. That's why even though I got the answer I wanted, I didn't get the whole answer. And I can't give the court a passing grade on this. I'll give them a D, maybe a C minus, because their work is so flawed. And that flaw shows they don't understand the law. They took an oath to support the Constitution of the United States. Now, again, I'll take the win. I like the win. But I'm sorry, the court failed again. And how many times have I brought up this First Amendment issue? Can nobody on the court read? It's funny, I was listening to a podcast this morning, and the host said the First Amendment contains 10 words that were important to a case. Congress shall make no law, and abridging the freedom of speech. And he said those 10 words are important, and then ignored the first 5. Just ignored the fact that Congress shall make no law in the rest of his reporting. That I'm not surprised. This is a podcast section on legal decisions, meaning they're probably trained by lawyers, by law schools, and law schools don't teach the Constitution anymore. I find it amazing that these allegedly intelligent people can't even read and understand the basic English in the document they've taken an oath to uphold. But that's my frustration. That's my pet peeve. What do you think? Do you think the court came to the right answer? Do you think they got the answer in the right way? And do you think it'll have an impact on future decisions? If so, please let me know. Just go to constitutionstudy.com/questions, ask what your opinion, or just give me an answer that you'd like me to cover. By the way, if you'd like me to answer your questions or include any content, you can always go to constitutionstudy.com/questions. And if you want me to answer it on the radio program, well, just hit the checkbox, answer it on America Out Loud Talk Radio, and I'll be happy to. This is why we, the people, every American, needs to read and study the Constitution of this country and teach the rising generation to be free. Because the people we hire to do so have failed. They've been taught a lie, not the truth. And even if they get the right answer at the end, their work shows their flaws. Now, hopefully you like the work that we do here. That takes a lot of time and effort researching these cases and other things that we do here. If you'd like to support us, there's a couple ways. One, well, you can always go to the website, constitutionstudy.com/shop, buy a book, buy a t-shirt, buy a mug, or just donate to the cause. You can also support our affiliates, like The Miracle of America, this great course I found that really covers our history from the Pilgrims through the founding. I liked it so much I made a deal with the owner to get you a lesson absolutely free. Just go to constitutionstudy.com/1776 study guide. That's the numerals, 1776 study guide. You'll be taken to a custom landing page where you can read about the course, read about the instructor, but best of all, there and only there, you can enroll for a free lesson on God's natural law. You get the downloadable study guide, you get an hour of content, audio or video, all of it absolutely free. But only by going to constitutionstudy.com/1776 study guide and clicking the button to enroll in your free lesson today. You can also support us with your cell phone. Patriot Mobile is America's only Christian conservative wireless provider. And I like them because, well, they're Christian conservative and they support organizations that are trying to protect our rights, including the Constitution Study. Just go to patriotmobile.com/constitution, find a plan that works for you. See if you're eligible for a discount. And when you check out, use the promo code Constitution to get free activation. That's right. You can support the Constitution Study with your cell phone by going to patriotmobile.com/constitution, enrolling there, and don't forget, use the code Constitution at checkout to get free activation. That's just some of the ways you can support the work that we're doing. The biggest way you can is by spreading the word, taking our links, our stories, our videos, all this content we create, and spreading it as far and as wide as you can. So by doing so, you're spreading not just the Constitution Study, but the very blessings of liberty we claim to value so highly. Of course, the other thing you can do is come back here next time, maybe bring a friend or two for the Constitution Study.